you need to be very cautious about what you are making the other person sign.
Just to add to what Ajinkya said, you as a startup would be employing so many employees. I mean, once your organization scales up, and that's when you want to be the crocodile over there.
Yeah,
so that's where
the money, be the crocodile.
Yeah, so that's where these things actually hold you.
Yeah, so there are certain very important things that you should keep in mind. One is the normal thing that what will be the remuneration, what will be the designation, place of employment, all those things I'm not going to highlight now. My point comes into the picture when we talk about the fourth point, confidentiality and non-disclosure. Very essential, very essential, because as we discussed earlier, it is the most unique part of the startup or an entrepreneur's daily is his idea. Is the idea that he conceives, is the idea that he brings to life by making that product. And if that itself, let's say you guys are computer engineers, I believe. So if your code gets stolen and if somebody builds another software out of this, similar software out of that code, it's a great loss to your own idea, it's a great loss to your own belief. So you have to make sure that you secure your interests by making the employee sign that he will not divulge the confidential information, he will not disclose the confidential data, the confidential tricks, business tips and tricks that he comes across. It's a very detailed and a very strong conclusive clause which I suggest that you guys should incorporate in your employment agreement. That will only go and ensure that your idea is fit.
Yeah, so I have this idea, but I'm afraid that it's vulnerable to many copies, and once I launch it into the market, I have the idea. So I'm afraid that it is very vulnerable, and if I launch it into the market, it can be like duplicated and many versions of it. So how can I protect my idea from
At this moment, well, I would just suggest that if it's a software code, is that what you're referring to? I would just suggest that at this moment you just put it on paper or on a data sheet or computer you can just store it. The reason is tomorrow when you are trying to liquidate, when you are trying to build something out of it, and if somebody tries to capture it or tries to take it off from you, you always have the valid justification saying, I have already prepared it on this date, and anything that is put on paper, as per the Copyright Act, anything that is put on paper, the author, by the mere fact of action of law, he gets the rights on that particular idea, on that particular write-up. So make sure that at least you can prove yourself to be the author of that code or that write-up at this very moment, with the date and day and everything, so that till the time you actually go live, your interests are secure. First thing. Second thing, sorry, I'm just trying. Secondly, you may eventually, you will be pitching your idea for investors or people who will be working with you as a co-founder. At that point of time, this particular clause will come to your rescue. Parth will be dealing with this NDA with investors as well as your co-founder. I think that also will solve your query. So, but as of now, make sure that you write it, put it on a piece of paper, maybe soft copy or hard copy, whatever, with the date and your name and everything, so that tomorrow when it gets under a dispute, at least under copyright law, you will get the protection.
So that would keep me safe even if the idea was even if the duplicated ideas bit vary, has some different.
Well, that is a disputable question, gentlemen. Because what happens?
It's certain that you were the first one to create that, so there should be some digital evidence showing that this idea was actually your original idea and it came into existence from that particular day. So if you can create some digital record with the date stamp, so I think that should suffice.
That should suffice. But now when you are saying that if somebody else, with a little bit of variation comes up with a similar product, then I am afraid that may not protect you as such. I was talking about a situation where your idea, exactly the way it is being copied by somebody else. But if it is being made changes into and some relatively different product is being produced, then I'm afraid this particular act will not secure your idea.
And just to add to what Ajinkya said, that will give you protection when you write a code and you go and talk to people. But if someone in America comes up with the same code as you and you're not able to establish that you had disclosed to someone and that guy came up with the same idea, so that's really difficult. So for that, what you have to do is actually get your idea copyrighted only then you can claim the rights to that code. So unless you do that, you won't be able to claim the right to that software code. Am I right?
That's right. Is that solved?
Yeah, thank you.
So we were talking about confidentiality and non-disclosure. Thereafter, there is this interesting clause called non-compete and non-solicitation. So now assume you at yourself as the employer, right? Now what happens is you have a couple of employees with you. You are, let's say, into a service industry. You have a product, you have a model of service, you're providing certain services. Now this employee stays with you from the inception to 3 years, and thereafter it just clicks to him that why should I not start off with the same business independently? Now he tries to solicit your clients, he tries to solicit your vendors, he tries to solicit and explore your contacts and tries to establish his own business. Now what do you think as the first one to conceive the idea? What do you think should be the situation? How you can secure it? Any inputs on this?
Maybe not allowing you to enter the particular order.
General, the thing is that you can't restrain them from entering an industry. What you can do is you can make them sign a particular clause, alright, saying that post separation with the company, you will not be able to solicit the company's clients, solicit or explore the company's vendors or its contacts or data, so that your interest is secured at least for 1 year. So it is imperative, it is very important for you as an employer to make sure that the agreement that you are signing with your employee has all these clauses. So now there was this non-compete, non-solicitation, confidentiality, non-disclosure, intellectual property. What the typical scenario in India is, as an employee, if I happen to develop a particular IP during the course of my employment with the company, in that event, the rights on that particular product will directly go to the company. This is draconian, I understand, but this is the law. So, if I develop, let's say, a software, if I develop, let's say, a particular idea, the IP on that will directly go to the company by the mere fact of certain settled judgments. But now, as an employee, you should try and negotiate that if it is possible for me as an employee with the company to negotiate that thing, अगर मैंने कोई IP develop किया है in the due course of my employment, I as an employee should be able to retain the rights on that property. It is possible to negotiate such clauses, but it has to be exclusively stated in the employment agreement. If it is not stated, then by the mere fact of the existing law, it directly goes to the company. So, three of the most important clauses that you need to state in your employment agreement. One is the non-disclosure confidentiality, one is the non-compete and the non-solicitation, and the third is the IPR. There are certain other clauses which I don't want to really sit and explain because they are very general clauses, like termination, you have resolution of disputes. There are certain employee-employer disputes that are going on over the period of time. You've been reading in news. So I won't really go into those things because those are not very difficult to understand. If you guys have any doubts on that, or if you have any problem in understanding that, you can anyway connect with me. But I want to focus on the most crisp and the most important parts of employment agreement. So, well, yeah, these are certain employment policies or HR policies that we have. Now, what happens is a company needs certain set of code of conduct or certain set of rules to regulate its employees. In such an event, company churns out certain policies, like we have certain policies like code of conduct and code of ethics, anti-discrimination, whistleblower, disclosure and resolution of conflict of interest. Now these policies are binding contracts on the employees and the employer. Now what is the necessity of such policy? It is for the better governance and the better functioning of the company. Because as Parth was insisting on mentioning about the due diligence that the investors conduct when they are investing in a company, necessarily these are the things that they check. Am I right?
Yeah.
So these are the points that they check. They verify whether there are certain healthy compliances happening in the company, whether the company has sustainable HR policies or not, whether they are investor friendly, whether it's an employee friendly company or not. So it is essential to have such kind of policies churned out so that your employees, they stay with you and they don't even disclose your information. So it's like a win-win situation for both the employee and the employer. But it is essential for us to understand that these HR policies should not be draconian or should not be very stringent or should not be very strangulating, because in that event what happens is there's a very bad thing in happening in the startup environment today. It's called the attrition rate, the running away of employees. If you have such stringent and such strangulating HR policies, it becomes suffocating for the employee to stay with the company and they just run away. So it should be very well balanced and very smartly drafted, so that it saves your, it secures your interest as well, and it also does not strangulate or suffocate the employee. So I think NDA will be taken care of by Parth.
The last part, and thanks to David Russell.
Yeah, for the last.
So a non-disclosure agreement is something that Ajinkya is going to do. So Ajinkya spoke to you in the context of signing a non-disclosure agreement with your employees. But I would suggest you sign a non-disclosure agreement with whoever you share your idea with. And when I'm stressing this, I'll just come to a story towards the end when you know what is the importance of a non-disclosure agreement. But so a non-disclosure agreement is actually an agreement where two parties decide. So you as a founder would be the disclosing party, and the person to whom you would be revealing that confidential information would be the receiving party. And whatever information that you're disclosing, be it the software code or your business ideas, all that would be covered under the definition of a confidential information. And for what purpose can that information be used, that will also be defined in that contract. So an NDA is actually a very essential contract for you to have handy whenever you're going out and speaking to some co-founders, or whenever you're going and speaking to some vendor, or some prospective employees whom you're going to pitch your idea about. So we have just written what are the broad contents. So the confidential information, it cannot be used for any other purpose. So it's defined that if I'm sharing this confidential information with you as a consultant, so you will only use that confidential information to advise you in my business. You can't use that confidential information to go and actually develop your own software. So that's where this agreement will be binding on that person, and you can actually sue that person for breach of contract. Can you put this together? So here is a tip: always share what you're going to do, but not how you're going to do. So whenever you're actually pitching your business idea at some open forums, or if you're going to speak to people and you don't have an NDA, or you feel that it's not necessary for me to reveal too much, so at that point in time, just share with them what you're going to do, but not how you're going to do, because how is the execution part, and that's where you have an upper hand. So so today, everyone knew that Uber existed, Ola or Lyft existed, but Ola did something. So they did replicate the idea. How they did it was something that Ola managed on its own. So this is something for you to learn. Okay, NDA is one document that will have potentially changed the history of Facebook. So tell me, how many of you guys have seen the movie Social Network over here? I'm sure all of you have. So you'll actually know what happens over there, right? So the Winklevoss twins, they tell Mark Zuckerberg to complete an incomplete code. It was just an oral contract. What Mark Zuckerberg does is 3 months down the line, he comes up with Facebook. So what was actually the source code for a website called Connect You, that was going to be developed by the Winklevoss twins, was actually used by Mark Zuckerberg to create Facebook. And then ultimately, Mark Zuckerberg settled with the Winklevoss twins for around $65 million. And at that point in time, if these guys would have just put out an NDA and shown in the code that this is one NDA that we had signed with Mark Zuckerberg, and there we have listed down and we have shared the source code for Connect You. So potentially today, the Winklevoss twins could have been the owners of Facebook and not Mark Zuckerberg. So now you guys actually realize how crucial this non-disclosure agreement is. So apart from everything, just keep this one thing in mind. Any questions, guys?
So okay, we come to the concluding part of, I think, the happiest slide for you guys. So we come to the conclusion part of this. So our intention of coming here was specifically to try and spread more awareness about the legal framework that is involved, because you guys are in the coming 4-5 years not just about entrepreneurship or startups, but in general, any legal queries, any legal questions that you need answers to, you have our coordinates. You can feel free to connect with me or Parth at any given point in time. And you guys being the budding entrepreneurs, we consider it as our privilege to help you guys with all your queries. And please feel free to call us anytime that you want if you have any queries.
We don't feel that we will bill you for any queries that you ask us. So
not now, not right now.
Not right now. Maybe when you are here.
Yeah.
So, but do reach out.
देखो बोल रहा हूँ ये लोग का प्रेजेंटेशन अभी चालू है 10 मिनट लगेगी
So any questions relating to today's session?
10 मिनट लगेगी इन लोग का प्रेजेंटेशन चालू है देख तालियां बज रही हैं इन लोग के लिए और इधर कोई स्टडीज ऑफ मैनेजमेंट डाल करके क्या बहुत मतलब काफ़ी अंदर आके एक्चुअली
It's not about, that's what I'm saying. It's not about the money. See, the thing is that there are firms like us, there are people like us who are more than willing to work with startups. Even from the inception stage, we are very flexible with our fee structures or revenue models. Because what happens is, today, as a startup, as an entrepreneur, it is extremely positive of you to think of having a legal person with you from the inception. Because what happens is, the first thing that you guys are attending this session itself goes out to prove that you guys are willing to understand this framework. So now that you've shown an inclination towards this, either you can approach us or there are other people in the field also you can consult, and I'm sure people will not hesitate to render their services to you without charging anything, unless of course something really big is being demanded. But it is essential for you to start off, at least what happens is your perspective is clear. When you are hiring a legal person to help you out with your things, let's say for your agreements or your documentation or the kind of scale up that you can expect from your product, it is essential for you to have that kind of legal perspective with you. So I suggest the right time is from the inception, from the conceiving of the idea, because as a gentleman out here, he could actually get his idea on paper, get it, so that his idea is secured and protected. So this kind of suggestions that you get from a lawyer is something that you won't really get otherwise. So it's better that you have this kind of discussions with lawyers from the inception.
In fact, from day one, you can need some form of legal assistance when you go for incorporation of your entity, when you go to investors for negotiating terms. So you would require some legal assistance from day one. So it's like something that you just cannot ignore. So I think that's something.
Anyone else?
I have a question not related to this. I'm doing my PhD, but I'm studying, so I'm a government employee. I want to be a social entrepreneur. So is there any legal issue?
Yes, so you want to start a not-for-profit organization, right? When you say a social venture, so you actually say that you don't want to earn a profit, but you want to do something for the society and want to build a self-sustaining organization. That's what you do. So there is one option. You can either do it through a trust. You can set up a trust under the Trust Act, which can actually get donations from people. If you want to do it in a corporatized manner, you can actually get a company incorporated in Section 8 of the New Companies Act. It's a not-for-profit company, and that company cannot declare dividends. So technically, you as an investor, once you put your money in, there's no way you're going to get your money back. But there are so many people out there who are willing to support social entrepreneurs. So many investors who are just willing to put in money just for the social benefit that it will have. So that's one possible route that you could take.
Did that resolve your query or not?
Government employee cannot be expected any profit.
So that's what we're talking about. We are not talking about any profit-making organization at the moment. Talking about trust, we spoke about trust and a non-profit organization. So both these things will not disqualify you from being a government employee. You are currently a government employee, right? So if you incorporate a non-profit organization, if you incorporate a trust, it will not disqualify you from your employment with whatever government organization that you are associated with. Alright, so that'll be all. Thank you very much for being patient.